His neck was split up. It was like they beat the out of him. That's what they did.
There is nothing to be said other than a cold-blooded with a baseball bat against a 70-year-old woman.
That will be the defining truth of their lives, that their father, her mother.
In May 2023, Joshua Farmer assaulted his ex-wife, Kayla Farmer, in front of one of their sons. A no-contact order was issued soon after, but it did little to prevent what came next. On the afternoon of June 28, 2023, while Kayla was stopped at a gas pump at a speedway in Fishers, Indiana, Joshua ambushed her. He fired into her car, killing the 32-year-old mother of 3 on the spot. Facing overwhelming evidence, Joshua Farmer accepted a plea deal in March 2024. At the sentencing hearing, Kayla's mother and sisters addressed him directly, expressing the deep pain he inflicted on their family.
No sentence will ever bring her back or erase the pain we live with every single day. But a just sentence can help us begin to heal. It can allow us to finally take a step forward, knowing that the person responsible has been held accountable.
Now her children will live with the reality that their father, her mother. That will be the defining truth of their lives. Their story will forever start with tragedy that they did not choose and didn't deserve.
Kayla's sister, Alicia, who has since adopted her sons, told Joshua he would be erased from their lives and no longer considered their father.
This is the last time you will be acknowledged by me or by anyone in our family. Once this hearing is over, you will be erased from our lives. You have no children. You have no legacy. The boys you once knew do not speak your name, and they never will.
Despite the emotional testimony, Joshua showed no remorse.
I don't have anything to say.
Prosecutors initially considered pursuing the death penalty or life without parole, but opted for the plea deal to spare the family a lengthy trial. He was sentenced that June to 80 years in prison. Farmer will be in his 90s before he is eligible for release. Lyda Shape had just marked her 70th birthday with a joyful celebration surrounded by family. But only a day later, that joy turned into horror. On April 28, 2025, while returning to her apartment at the Ten Trumbull luxury complex in Trumbull, Connecticut, she was ambushed by her former son-in-law, 45-year-old Ili Shtapaku of Norwalk. After seeing her at the Trumbull Mall with a visiting relative, Shtapaku followed them back to the complex. Security footage captured the moment when he opened his trunk, pulled out a weapon, and viciously attacked Shape outside the clubhouse. By the time first responders arrived, Shape was critically injured and was pronounced dead at 12:55 p.m.
The deceased just turned 70 years old Sunday night. The family had a wonderful party for her. The entire family is devastated. Their mother was their everything, and now she's gone. There is nothing to be said other than a cold-blooded with a baseball bat against a 70-year-old woman.
Shtapaku remained at the scene and was immediately taken into custody. According to the police report, he made an unprompted confession. In a later interview, he claimed he held Shape responsible for his divorce, financial problems, and the loss of his home.
Court makes a finding of probable cause for the charge alleged.
He was arraigned on a murder charge at Bridgeport Superior Court, where a judge cited the brutal nature of the crime and the overwhelming evidence before setting his bond at $3 million. The court also ordered a psychiatric evaluation. In May 2020, just weeks before his high school graduation, 18-year-old Gregory James was shot and killed in Louisville's Chickasaw neighborhood during a drug-related incident. Police later arrested 5 young men in connection with the killing: Remigio Minefield, Garrett Minefield, James Clifton, Andrew Dew, and Gemetrian Houston. Investigators determined that Remigio Minefield fired the fatal shot, striking James. All 5 were charged in the case, and over the following 2 years, legal proceedings gradually moved forward. By June 2022, each of the defendants had accepted plea deals.
Let's get through this. I know it's difficult.
What's the problem with this case? Why we can't go to the max? But somebody just basically admitting that they murdered someone.
The victim's family, forced to accept Gregory's diploma posthumously, left the courtroom heartbroken and angry.
When you all kill someone, you are not just killing them, you are killing their family, their loved ones, their friends. I wish the violence would stop. In a way, we got, I guess you would say, good news, because they're off the streets. But in our hearts, 20 years is not enough.
Though the young men were brought to justice, the family felt the sentences fell short, unable to reflect the life lost or ease their pain.
Yes, I plead guilty.
How do you plead?
I plead guilty.
Remigio Minefield was sentenced to 20 years in prison, while Clifton, Dew, Houston, and Garrett Minefield each received 15-year terms. However, Garrett, who was a minor at the time of the crime, will return to court in August for formal sentencing, where his attorney plans to request probation. On May 30th, 2024, Connecticut State Trooper First Class Aaron Pelletier was conducting a routine traffic stop on Interstate 84 in Southington when tragedy struck. As he stood on the shoulder, a pickup truck driven by 45-year-old Alex Oyola Sanchez veered off the road, striking Pelletier, his cruiser, and the vehicle he had pulled over. Oyola Sanchez fled the scene but was captured shortly afterward thanks to a witness who followed him and alerted police. At the time of his arrest, he was visibly under the influence and later admitted to using fentanyl and cocaine that day. Further investigation revealed a violent criminal history from Puerto Rico, including past convictions for murder and attempted homicide.
There's a charge of manslaughter in the first degree.
In early 2025, Oyola Sanchez pleaded guilty to first-degree manslaughter. During the sentencing in April, Trooper Pelletier's wife, Dominique, delivered an emotional statement, expressing how their two young sons still ask when their father will return.
My younger son, Zachary, will ask at least once a day when Daddy's coming home from heaven because he's been there too long.
Fellow officers also came to seek justice.
He was unique. His family is unique. Dominique, Zachary, and Troy, we will forever take care of in his absence. That's a fact.
Through an interpreter, Sanchez expressed remorse, but for the Pelletier family, no apology could restore the devoted husband, father, and trooper they lost forever.
I'm sorry because it was not my intention. I ask the family for forgiveness. I hope the sound of these words I'm speaking to you resonate with you in any quiet moment you have. I will never forgive you.
Despite pleas from the family and fellow officers for a harsher punishment, the judge upheld the plea agreement, emphasizing the value of avoiding a lengthy trial. Sanchez was sentenced to 18 years in prison. In October 2017, 5 boys from Clio, Michigan threw rocks from an overpass, killing 32-year-old Kenneth White as he drove home. Kyle Anger, who threw the fatal rock, pleaded guilty to second-degree murder and was sentenced to up to 20 years, later paroled in 2021. The other 4 boys pleaded guilty to manslaughter under a juvenile sentencing deal. Their actions were uncovered through surveillance footage and incriminating messages.
I'm also, frankly, tired of playing tennis with myself on this case.
However, Genesee County Circuit Judge Joseph Farah rejected the deal, citing the calculated nature of the crime and the lack of remorse shown.
There will be no jail sentence. There will be no prison sentence. That person in juvenile court will be considered to be on probation.
Defense attorneys expressed strong disagreement.
Everybody on this case has said that this is a juvenile case that should be resolved with a juvenile sentence. The only one that has not said that is Judge Farah. And he has his reasons and he has the authority to say that. But that should in no way deter us.
The case law is very clear that any type of plea bargaining would come from the prosecutors and the defense attorney, and the judge plays absolutely no role in that.
They argued that the judge had overstepped by refusing a deal endorsed by the prosecutor, which they believed should determine the outcome. The case proceeded in adult court, but the Michigan Court of Appeals later ruled that the adult charges could be dismissed, allowing for proceedings in juvenile court. In August 2021, Sikelski, Gray, and Payne were each sentenced to 1 year of probation and 100 hours of community service, while Miller received a sentence of 330 days in jail. In 2012, 19-year-old Alex Zaldivar was murdered during a violent home invasion in Ocoee, Florida, and Bessman Okafor was later convicted of the crime and sentenced to death. However, because his death sentence was not decided unanimously by the jury, as now required by law, it was overturned, prompting a resentencing trial in 2023. As the new trial moved forward, it was abruptly halted when juror Kayla Pena claimed she had discussed the case with a friend and could no longer be impartial, forcing the judge to declare declare a mistrial. Later, in a court hearing, DePena admitted she had lied about the conversation. Her real reason, she confessed, was that she was frustrated about being sequestered and missing work. Fellow jurors confirmed she had expressed her intent to disrupt the trial, even stating she would cause a mistrial.
She was upset. She said that she needed to be at work that night. We were called back in the room, and the judge told us we were going to be sequestered for the night, explained the rules, and then we went back into the deliberation room, and she asked to speak to the judge. And before she walked out, she said she was about to make that a mistrial.
In response, Judge Mark Bleckman found her guilty of direct criminal contempt and sentenced her to 179 days in jail and a $500 fine. Despite the delay, Okafor's second penalty phase resumed, and a new jury recommended the death penalty by a 9-3 vote. On June 24, 2024, Okafor was sentenced to death. In May 2023, a fatal shooting in East Central Fresno left 56-year-old Michael Brady dead and his 80-year-old landlord, Ira Gordon Lewis, on trial for murder. The two men reportedly had a long-standing dispute over unpaid rent at a property near East Dakota and North Haston Avenues. On the day of the incident, Brady was found critically wounded outside the residence and later died at Community Regional Medical Center. Authorities arrested Lewis at the scene. During his trial, prosecutors presented evidence that the shooting was the result of escalating tensions, while Lewis claimed he acted in self-defense after Brady allegedly approached him with a dangerous tool.
Well, I put a round in him. I fired a bullet into him.
Still standing in the same spot?
Didn't slow him down one bit.
The courtroom heard emotional testimony from Lewis's granddaughter, Janae McAllister, who recounted a past incident where she saw her grandfather mimicking a shooting gesture, suggesting a pattern of aggressive behavior.
I went out to see what was going on, and I saw Ira at the other house with his arms up as if he were shooting at the dog.
She also described locking doors out of fear on the day of the shooting.
Yes, I locked the door and then I put in the slot for the doggy door to close that as well.
Why did you do that?
Because I was scared.
Of what?
My grandma.
The defense attempted to suggest that Brady had provoked Lewis, referencing a vulgar message allegedly written on the tenant's wall, though no witness confirmed seeing it. Both sides concluded their arguments, and closing statements followed. If convicted, Lewis could face a sentence of 50 years or more in prison. On July 20th, 2024, Virginio Cortez was helping his granddaughter change a flat tire on the shoulder of Highway 101 near Laurel Drive in Salinas when tragedy struck. His daughter stood nearby, directing traffic to ensure their safety. Suddenly, 25-year-old Jose Sanchez, driving under the influence with a blood alcohol level of 0.22, more than twice the legal limit, veered off the road and slammed into Cortez, him instantly and injuring his daughter. Sanchez was later charged with gross vehicular manslaughter while intoxicated and DUI causing injury. In court, Sanchez apologized and asked for forgiveness.
Took Mr. Cortez's future from his family. And I heard Miss Crystal Cortez, I am truly sorry you will not be able to hold each other again.
Cortez's grieving family expressed that no punishment could undo the loss. Still, they hoped Sanchez would learn from the consequences of his actions and carry the weight of that responsibility moving forward.
Like the judge has mentioned, there is no justice to be served. Nothing will bring my dad back. Nothing will make any of it better. But however, as long as some time is being served, as long as, the defendant learns from his actions and actually uses this as a second chance at life, live for my dad.
The judge echoed that sentiment, acknowledging the pain of the family and the irreversible damage caused by a single reckless choice. Sanchez pleaded no contest and was sentenced to 7 years and 8 months in state prison. In March 2015, 18-year-old Anjelica AJ Hadsell, a freshman at Longwood University, returned to her Norfolk, Virginia home for spring break and never came back. She vanished on March 2nd, leaving behind a note suggesting she needed space, but when days passed without contact, the situation turned serious. Her stepfather, Wesley Hadsell, took an active role in the search, even speaking to the media, but investigators soon grew suspicious. Wesley had a criminal history, and surveillance and GPS evidence traced his movements to an abandoned property in Southampton County. On April 9th, AJ's body was discovered behind that very house. The medical examiner found heroin in her system, despite AJ having no known history of drug use. Authorities later found heroin stashed in the ceiling of Wesley's hotel room and concluded he had drugged and killed AJ, then tried to frame one of her friends by planting false evidence. Wesley Hadsell was initially arrested on unrelated charges, but in 2018, he was formally indicted for AJ's murder. After a mistrial in 2020, his second trial in 2022 ended with a conviction for first-degree murder, concealment of a body, and drug possession while incarcerated. He was sentenced to life in prison plus 15 years. The judge condemned his actions as some of the most cold-hearted the court had seen, stating Hadsell had earned every day of his sentence. AJ's grieving family did not attend the sentencing, unable to bear the emotional toll, but her former stepfather, Zach Hoffer, tried to speak and had to be physically removed after an outburst. Hadsell, who sat emotionless throughout the hearing, has filed plans to appeal. Tyre DeAndre Nichols was born on June 5, 1993, in Sacramento, California. Known for his love of photography and skateboarding, Tyre was described by those close to him as gentle, artistic, and soft-spoken. On the night of January 7, 2023, Tyre Nichols was pulled over by Memphis police officers who claimed he was driving recklessly. What started as a routine traffic stop soon escalated. Officers removed him from his vehicle, used pepper spray and a taser, and gave conflicting commands. Overwhelmed, Nichols ran, but was later caught by the officers. During the encounter that followed, he sustained serious injuries. Despite his condition, he did not receive immediate medical assistance. 3 days later, on January 10, 2023, Nichols died in the hospital from the injuries he sustained. An independent autopsy revealed extensive injuries consistent with a violent physical assault. Following his death, the Memphis Police Department took swift action. Between January 20th and 27th, the 5 officers involved, Tadarius Bean, Demetrius Haley, Emmett Martin III, Desmond Mills Jr., and Justin Smith were fired. On January 27, 2023, police released body camera and surveillance footage. The video showed the shocking reality of what Nichols endured and ignited nationwide protests against police brutality.
This is a full cam video from the incident location.
The legal consequences began unfolding quickly. On January 26, 2023, the officers were indicted on multiple charges, including second-degree murder, aggravated assault, and official misconduct. They were arrested and released on bond shortly after. In February, each of them pleaded not guilty to the charges. On April 19, 2023, Nichols' family filed a $550 million lawsuit against the city of Memphis, the police department, and the officers involved. The lawsuit blamed the aggressive tactics of the Scorpion Unit, a specialized police team designed to reduce crime in high-risk areas, for creating a culture of violence that led to Nichols' death. In October 2023, federal charges were brought against the officers for violating Nichols' civil rights. 2 officers, Desmond Mills Jr. and Emmett Martin III, pleaded guilty and agreed to testify. The remaining 3, Bean, Haley, and Smith, chose to stand trial. Their state trial began on April 28, 2025. Rovon Wells, the mother of Tyre Nichols, gave an emotional testimony recounting the last day she saw her son alive, describing how he left home on January 7, 2023, after a warm conversation about dinner, never to return. That evening, officers informed her he had been arrested for DUI, a claim she doubted given his mild habits. Hours later, she found his abandoned car near their home and, at 4 a.m., received a call from a hospital doctor revealing Tyre was critically injured. When she arrived at the hospital, she found her son beaten beyond recognition and unresponsive, sustained only by machines. She knew instantly he was already gone. Days later, she received the call confirming his death.
My husband went to the door. I heard a gentleman say, does Tyre Nichols live here? My husband, he paused a second, and then I came to the door, and I said, yes, Tyre lives here. I'm his mother. What's going on? They proceeded to tell me, the police officer that was at the door, it was actually 2 police officers at the door. One proceeded to tell me that Tyre was arrested. And I asked them why he was arrested. And they said for DUI. And DUI, that didn't sound right to me.
And tell the jury, why didn't that make sense to you?
Because my son, he doesn't drink like that to have a DUI. We're not drinkers in our families. So Ty would barely drink a beer, or something. So it just didn't seem right to me. They proceeded to ask me, was he on drugs? Did he do any type of drugs? And I said, no, he don't do any type of drugs. Smoke a little marijuana. And I said, why? They said because he had all this wild strength and all this strength and everything, and they had to end up pepper spraying him and tasing him. And that still didn't sound right to me. And I made a statement. Well, if all of that happened, then somebody must have put something in his drink or something if they were saying all of this stuff happened. So the officer told me that they're going to be taking my son to the hospital. I asked him where my son was, and the officer said he was nearby. And I said, nearby? And they said they were going to take him to the hospital because he had been tased and pepper sprayed. I said, well, okay, what hospital is he going to? I need to go. The officer told me that I could not go because Ty was arrested. Hospital and go see Ty.
And is that what you did?
Yes.
Who went to the hospital with you at that time?
My cousin Tony. She came over to meet us, and my husband and I.
What hospital was Ty at?
At St. Francis Hospital.
And tell the jury what happened when you walked into St. Francis.
As we were walking into St. Francis, there was another officer walking in. We were kind of going in the same direction, so I asked you're working late tonight, huh? He said, yes. He said, I'm here to sit with a prisoner. And I said, well, is the prisoner's name Tyre Nichols? And he said, yes. And I said, well, that's my son. He said, oh, okay, well, follow me. So we all proceeded to walk to Ty's room.
Ms. Wells, I know this is going to be difficult, but I want you to explain for the jury when you went in Ty's room what you saw, what Tyre looked like, what you saw, what you felt, what happened in that moment.
When I walked into the room and I saw my son, I immediately went over to him and I fell out on him because my son was beaten to a... His head was the size of a watermelon. His nose was broken. His neck was split from the swelling. He was bruised from head to toe. It was like they beat the shit out of him. That's what they did. They beat the shit out of my son and left him for dead. That's what they did.
And Ms. Wells, were there other officers in that hospital room when you walked in?
The doctor was there. There were some other officers in there. Once I saw my son and I basically passed out on him, basically. I just laid on him and just started crying. And I just burst out and said, what the f is going on here? This does not look like no pepper spray and no tasing. And a police officer took my husband and I out the room. My cousin stayed there and took us into another room. I want to say it was a sergeant or captain, I can't remember. We spoke briefly. And then next thing you know, all of Shelby County police and everybody was out the room. They said TBI had taken over the case. And all the police officers that were there were gone. And so it was just the TBI, the nurses, the doctor, and my husband and my cousin. We were in the room with my son.
When you saw your son, was he ever responsive to you that night?
No. Tyre was not responsive. He was on a breathing machine, and the machine was keeping him alive.
And did you know from the minute you walked in that room that night that your son was gone?
Yes. You couldn't. There's no way my son would have survived from that. He was already deceased, basically. I say.
After nearly 2 weeks of testimony and deliberations, on May 7th, a jury acquitted all 3 of the most serious charges, including second-degree murder.
Jury, having found that this is a unanimous verdict, the court will read the verdict as follows. In indictment 2300241, State of Tennessee versus Darius Bean, Demetrius Haley, and Justin Smith, if counsel would like to stand with their clients. The verdicts read as follows. Count 1, second-degree murder. We, the jury, find the defendant, Darius Bean, not guilty. Count 1. We, the jury, find the defendant, Demetrius Haley, not guilty. Count 1. We, the jury, find the defendant, Justice Smith, not guilty. Count 2. Aggravated assault, acting in concert. We, the jury, find the defendant, Darius Bean, not guilty. Count 2. We, the jury, find the defendant, Demetrius Haley, not guilty. Count 2, we the jury find the defendant, Justin Smith, not guilty. Count 3, aggravated kidnapping with bodily injury. We the jury find the defendant, Tadarius Bean, not guilty. Count 3, we the jury find the defendant, Demetrius Haley, not guilty. Count 3, we the jury find the defendant, Justin Smith, not guilty. Count 4, aggravated kidnapping with a deadly weapon. We the jury find the defendant, Tadarius Bean, not guilty. Count 4, we the jury find the defendant, Demetrius Haley, not guilty. Count 4, we the jury find the defendant, Justin Smith, not guilty. Count 5, official misconduct, unauthorized exercise of official authority. We the jury find the defendant, Tadarius Bean, not guilty. Count 5, we the jury find the defendant, Demetrius Haley, not guilty. Count 5, we the jury find the defendant, Justin Smith, not guilty. Count 6, official misconduct, refraining from performing a duty. We the jury find the defendant, Tadarius Bean, not guilty. We the jury find the defendant, Demetrius Haley, not guilty. We the jury find the defendant, Justin Smith, not guilty. Count 7, official oppression. We the jury find the defendant, Tadarius Bean, not guilty. Count 7, we the jury find the defendant, Demetrius Haley, not guilty. Count 7, we the jury find the defendant, Justin Smith, not guilty.
The verdict stunned and devastated Nichols' family and sparked renewed criticism from civil rights activists who saw the decision as a failure of the justice system. Despite the acquittal in state court, the officers still face federal charges related to civil rights violations. In the aftermath, the Memphis Police Department disbanded the SCORPION unit. The U.S. Department of Justice launched an investigation into the department's broader patterns and practices. Nationwide, the public called once again for police reform. In August 2023, Jesse Garcia Jr., a 29-year-old man with a history of violent offenses, was already out on bond for multiple felony charges when he triggered a series of events that rocked the city of San Antonio. Despite 2 active felony bonds, Garcia remained free. By late August, he was once again wanted, this time on fresh felony warrants, including charges for being a felon in possession of a firearm and evading arrest. On the afternoon of August 24, 2023, San Antonio Police Department officers attempted to arrest Garcia. As they approached, he fled, leading authorities on a high-speed pursuit through the city. During the chase, Garcia fired out of the back window of a moving vehicle. Officer Rhett Shoquist was critically wounded, and Officer Raul Chavez suffered several serious injuries. The violent encounter left the department and community shaken. Garcia eventually abandoned the vehicle and barricaded himself inside a nearby apartment, prompting a tense 4-hour standoff with law enforcement. The situation came to an end when Garcia finally surrendered and was taken into custody. Following his arrest, Garcia was formally charged in 10 criminal cases, including 5 counts of aggravated assault against a public servant, each a first-degree felony, 2 counts of aggravated robbery, and additional third-degree felonies such as theft, unlawful possession of a firearm, and evading arrest in a vehicle. On February 19, 2025, Jesse Garcia Jr. appeared before Judge Joel Perez in Bezar County and entered no contest pleas to all charges. The court reviewed the plea agreement and accepted the terms.
I'll accept his plea in all the cases. I'll accept his plea. I'll find that he's mentally competent. Okay, we'll do.
State offer states one in evidence in all attachments, Judge. In all cause numbers, all 10 causes.
Okay. And just to make sure, I'll make sure that in all these cases, I'll find he's voluntarily waiving his rights, that he's mentally competent, and I've accepted his plea. And to all the stipulations, counsel, do you have any objection?
No objection.
Could there being no objection in all these cases, I'll admit states one, find that they support the plea and make them part of the record. Okay, so now in 2023 CR 10471, 2023 CR 10479, 2023 CR 10476, 2023 CR 10477, and 2023 CR 10480. Based, they're all aggravated assaults against a public servant. I will find them guilty based on the stipulations of the felony of the first degree. And then in 2023 CR 10472 and 2023 CR 10473, the aggravated robberies, felonies of the first degree, I will find them guilty of that offense. In 2023 CR 7746, the unlawful, felon in possession of a firearm, a felony of the third degree, I will find them guilty based on the stipulations. Under 2023 CR 7747, evading arrest, a felony of the third degree, I will find them guilty. And in 2023 CR 11378, the theft, 30,000 to 150,000, a felony of the third degree, I will find them guilty.
During sentencing, victim impact statements delivered by injured officers and their families provided emotional closure. Officer Shawquist returned to duty in 2024 and stood before the court to deliver a message directly to Garcia.
Defendant, you're nameless. You are unimportant. You are a coward. If you'd gone toe-to-toe with me that day in a straight-up fight, you would not be alive here now. But you ran away like a scared little boy, and you fought like a scared little bitch. I will continue to enjoy my freedom and my time with my family and friends. You will be in a cage where you belong. Cowards don't fare well in TDC. So, good luck.
I have to work.
All right. I only have a few things to say to you because you're not worth any more of my time or energy. On August 24th, 2023, you decided to put countless innocent lives at risk and affect the lives of many of us in this room. Rather than face the consequence of your actions like a man, when you were surrounded and knew that you could no longer take any lucky cheap shots at us, you surrender like the coward you are. We all know the punishment that you should have received that day, but knowing you'll be rotting in the cell while we get to enjoy our lives will give us some compensation.
Before I go on, I want to be very clear that I'm speaking directly to you, Jesse. All these other people in this room don't matter. I think that, just like Raul, I'm not going to spend a lot of time speaking because you're not worth my time. You're not worth anyone's time in this room. And if there are people in this room who care about you, you're wasting a lot of time with them. All because you couldn't hold yourself accountable for the things that you were supposed to do. But like they said, you ran like a coward. And you should have stood your ground. I want you to know that if you get out someday, whether it's me and myself, or the generation after me, or the next one, or the next one, if you can't hold yourself accountable for your actions, we'll be waiting. Maybe you figure out a way to do that, but I don't think that's likely because I don't think that's who you are. You're 29 years old. You would have figured it out by now.
He called him a coward for endangering lives and fleeing responsibility, and told him that while he would spend decades behind bars, the officers and their families would continue living their lives in strength. Officer Chavez echoed these sentiments, stating that Garcia's refusal to accept responsibility only strengthened their resolve. Rachel Shoquist, Officer Shoquist's mother, described the harrowing hours after receiving the call about her son's injuries.
Hi, good morning. My name is Rachel Shoquist, and I'm the mother of Officer Brett Shoquist. On the evening of August 24th, 2023, I received the call that my son had been seriously injured. I drove from Austin to San Antonio, and it was a lifetime. When I got to the hospital, they had already taken Brett into surgery. It lasted 8 hours. Another lifetime. When we were able to see Brett, the first things that he said to us was that he was good, he was strong, and he was grateful. At that point, I knew, and it was confirmed what everyone already knew, that he's a warrior. Jesse, you didn't make anybody weaker or scared that day. You made everyone stronger. You made my son stronger. You made the police department stronger and more determined to take people like you off the street. Please make no mistake that any tears shed here today are not out of fear or sadness. They're out of joy and gratitude. Gratitude that you will be spending 45 years of your life behind bars where you deserve. And joy that we have our families with us, that Rhett is with us and with his family where he deserves to be.
She recalled driving from Austin to San Antonio in fear, waiting during her son's 8-hour surgery, and ultimately realizing the strength and resilience her son embodied.
Then in all those cases, because I have followed your plea agreement, you do not have my permission to appeal. And I'll give you copies for your lawyer in a minute, okay? In 2023 CR 10472 and 2023 CR 10473, the aggravated robberies, felonies of the first degree, I will find them guilty. I will sentence him to 45 years, Texas Department of Criminal Justice Institutional Division. I'm going to give him credit for time served. I'm going to impose a $1,000 fine in those two cases. Those two cases are to run concurrent with each other and concurrent with the other 5 cases, so they're all running concurrent. And then I'm going to TIC the same cases and that I just TIC'd in the other cases, okay? If I didn't say it, I'm getting credit for time served in these cases also, okay? Okay, then, in 2023 CR 7746, the unlawful carrying or felon in possession, in 2023 CR 7747, and in 2023 CR 11378, they're all felonies of the third degree. I'm going to find them guilty. I'm going to sentence him in all those three cases to 10 years, the Texas Department of Criminal Justice Institutional Division. I'm going to give him credit for time served. I'm going to run these three cases concurrent with each other and concurrent with the aggravated robberies and with the aggravated assaults on a public servant. You're getting credit for time served. And I'm going to take into consideration in these two cases the same cases I took into consideration in the other cases. And so in all these cases, sir, there's a trial court certificate. I just showed you one. In all these cases, did you sign the trial court certificate waiving your right to appeal?
Yeah.
Okay, in all these cases, because I followed your plea agreement.
Garcia was sentenced to 45 years in the Texas Department of Criminal Justice. The sentence covered all 10 cases and was ordered to run concurrently. He also received a $1,000 fine in each first-degree case and credit for time already served. Under Texas law, Garcia will be eligible for parole after serving at least half of his sentence. In 1987, a brutal double homicide in Millington, Tennessee, led to the arrest and conviction of 20-year-old Pervis Payne. He was found guilty of killing Cheris Christophers and her daughter, Lacey Jo, while seriously injuring Christopher's son, Nicholas, who survived. Payne, who has consistently maintained his innocence, was sentenced to death in 1988. His case became a landmark when it reached the U.S. Supreme Court in Payne v. Tennessee, 1991, which allowed victim impact statements during sentencing, a precedent still used today. Years later, in 2002, the legal landscape shifted when the U.S. Supreme Court ruled that executing individuals with intellectual disabilities violated the Eighth Amendment. However, Tennessee at that time had no process in place for prisoners like Payne to challenge their sentences based on intellectual disability. That changed in 2021 when the Tennessee legislature passed a law allowing such claims to be reviewed in court. Following that change, Payne's legal team submitted a petition arguing that he was intellectually disabled. Their claim was supported by 2 court-appointed experts, and in November 2021, the Shelby County District Attorney agreed that Payne met the legal criteria. As a result, his death sentence was vacated.
All right, well, the order is vacate the capital sentences of Mr. Payne based on the findings of the experts in this matter that he is intellectually disabled. So the death sentences are hereby vacated or set aside. And now, Ms. Henry, you wish to revisit the sentencing issues. Why don't you just present your position?
Thank you, Your Honor. Your Honor, it is going to be our position that Your Honor should sentence Mr. Payne to concurrent life sentences in case numbers 09 and 10. Your Honor, I've conducted some additional research and I will provide briefing, but I would initially direct the court to the ruling out of the Gibson County case, State versus Ronald Cawthorn. Last name is spelled Cauthren. That case was a 1987 case where Mr. Cawthorn received 2 consecutive death sentences, consecutive to 2 non-capital counts that were found. His case was, the death sentences were vacated and the case was remanded for sentencing to the Gibson County Court. That court held a hearing in 2016 and found that TCA 40-35-117 made the Sentencing Reform Act applicable to the resentencing in his case, and that's found at 40-35-115. There is a presumption of concurrent sentences under the law of Tennessee, and there is a presumption that, or there's actually, it's mandatory that sentences be run concurrent unless one of the so-called gray factors, which were codified in 40-35-115, are found. It will be our position that none of those factors apply to Mr. Payne. We will present proof on December 13th as to the only arguably, there are 8 factors, there's only one that could potentially apply, and that's dangerous offender. And we will present evidence and testimony that Mr. Payne is not a dangerous offender, and that in fact for 34 years he has been without, his record is without blemish, and he is a person who is amenable to potentially one day reaching parole. I do not mean to presume in any way, shape, or form what this court will do in terms of running the sentences concurrent or consecutive. We were in the court briefly on Friday to discuss this matter, and I believe Mr. Jones indicated that he believed that it was law of the case, that the court didn't have any jurisdiction but to sentence Mr. Payne to 2 consecutive life sentences. The Cawthorn case rebuts that argument, as well as the case of State versus Sledge, which is found at 2003 Westlaw 57313, a Court of Criminal Appeals opinion from 2003, where the Court of Criminal Appeals specifically held that the law of the case doctrine is not a constitutional mandate nor a limitation on the power of the court. Rather, it is a long-standing discretionary rule of judicial practice. We will argue, as the judge in the Cawthorn case did, that this court's discretion in this matter should be exercised to sentence Mr. Payne to concurrent sentences, because in fact there's new evidence, and that's one of the things that the Sledge court looked at, is whether there's new evidence on the issue of concurrent versus consecutive. And
that Sledge case was out of Shelby County.
Yes, ma'am. It's a Shelby County case.
What's the first name of Sledge? You know?
Fred Sledge. I believe Your Honor is familiar with the cases.
I believe I am,
yes,
too. I believe I was the defense lawyer in that case.
Yes, ma'am. Yes, ma'am. And though Mr. Sledge was not successful, the court did specifically note that the matter of law of the case is a discretionary one, not a mandatory one. So there's no collateral estoppel that prevents this court from considering concurrent versus consecutive sentencing, and that's what the court in Cawthorn found.
Attention then turned to resentencing. A hearing was held in December 2021 to determine whether Payne's life sentences would be served one after the other consecutively or at the same time concurrently. Prosecutors argued for consecutive terms, which would keep Payne behind bars for the rest of his life. In contrast, the defense highlighted his clean prison record over more than 3 decades and asked the court to consider concurrent terms, which would make him eligible for parole soon. On January 31st, 2022, Judge Paula Scahan ruled that Payne's sentences would run concurrently. The judge cited Payne's long-term good behavior and the lack of evidence showing he posed a current danger to society. This decision meant that Payne could seek parole after completing 39 years in prison. The Tennessee Court of Criminal Appeals later upheld that decision in August 2023, affirming that Payne had not been proven to be a danger and confirming his eligibility for parole in 2027. After more than 3 decades on death row, Payne now awaits the opportunity to argue for his release under supervision. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.